During the 10th IBP National Convention, held in Baguio City on April 20, 2005, last year, I had the occasion to discuss initially my philosophy of liberty and prosperity for both the bench and the bar. Today, in the midst of the present crisis of confidence and credibility facing our country and our people, I reiterate my call for a revitalized legal profession guided by the same twin beacons of democracy and development, ethics and economics, integrity and investments, which are all restatements of liberty and prosperity. To be sure, lawyers have a great role in shaping public opinion. Not only do they raise the people's consciousness of burning issues, they also reflect the nation's pulse. Members of the bar are almost always consulted and their views obtained on almost any conceivable topic of importance, on presidential issuances, legislative proposals and enactments, elections, and sometimes even fashion. Sadly, however, some lawyers have forgotten the great burdens that come with their awesome responsibility and authority. Some have become so adept at being technicians of the law that they have come to regard it as the end rather than a means of something much more important. Indeed, many lawyers have had so much success defending their clients' causes for right or for wrong that they have lost sight of their first and foremost duty, which is to serve the ends of truth and justice. Worse, some have jumbled up their hierarchy of responsibilities to put up their interests first, those of their clients second, and justice a far third. Thus, I remind you that the practice of the profession is built and founded on much loftier objectives. To the ends of truth and justice, I add a call to defend liberty and to nurture prosperity. This legal philosophy of liberty and prosperity, or democracy and development, finds basis in the 1987 Constitution. The defense of our people's liberty is largely enshrined in our Bill of Rights, and the nurturing of economic prosperity is enunciated in various provisions of the Declaration of Principles and State Policies, and of the National Economy and Patrimony. In particular, Section 1 of Article 12 of the Constitution mandates, and I quote, a more equitable distribution of opportunities, income, and wealth, unquote, and thereby presages prosperity as a veritable economic right of our people. But competence in the law is not enough. It should be coupled with ethics, stressing the lawyer's public responsibility. The Supreme Court, in one case, stated, and I quote, with their ubiquitous presence in the social milieu, lawyers have to be responsible. The problems they create in lawyering become public difficulties. To keep lawyers responsible underlies the worth of the ethics of lawyering. Indeed, legal ethics is simply the aesthetic term for professional responsibility. Close quotation. Attempts to define ethical conduct for lawyers have been made through the enactment of laws and rules of professional conduct that establish standards of propriety. But these laws and rules do little to define criteria of ethical conduct, precisely because of the myriad of possible scenarios that can be drawn from lawyers' professional practice and related experiences. In my books and addresses, I have always stressed that an ethical compass is required of lawyers. Ethics in our profession cannot be overemphasized. Attorneys are always expected to uphold fidelity to truth and justice. Quality justice always begins with a high standard of ethics. So much of a lawyer's professional life depends on ethical values and moral behavior, not just within the inner circles of professional associations, but also outside and beyond them. When I was practicing law more than a decade ago, a wealthy businessman visited me. He told me, "I know that your law office is composed of competent bar top-notchers who are experienced in the labyrinths of the law. But my question is, do you also know the judge in whose sala my case is pending? It is good to know the law, but it's even better to know the judge," he said. Upon learning these remarks, my partners and I respectfully declined the case, even if it meant losing a sizable retainer. Legal practitioners with a strong and firm sense of right and wrong behave in accordance with what is true and honest, regardless of personal consequences. Those with personal dignity possess the moral courage to denounce wrong and to promote truth.